Welcome to Synergy's Putting It All Together Medicare 101 webinar. Attorneys often experience an extra layer of stress when it comes to settlements involving Medicare beneficiaries. We've all seen cases where law firms have been pursued by the Department of Justice for failure to address conditional payments and settlements. We've seen cases where settlements have fallen apart because the parties were not on the same page when it came to Medicare compliance. Unfortunately, we have also seen situations where Medicare has denied post-settlement injury-related care because of a settlement. Now, a lot of the unease around Medicare Secondary Payer Compliance issues comes from the fact that most attorneys are not familiar with the way the Medicare Secondary Payer Framework is set up. Our Putting It All Together Medicare 101 webinar will give you an overview of Medicare's conditional payment recovery process and the way that it is tied into Section 111 Mandatory Insurer Reporting, and highlight the importance of selecting proper ICD-10 diagnosis codes when it comes to reporting. My colleague, Teresa Kenyon, will also go over the Medicare Secondary Payer Recovery portal and conditional payment dispute process. My name is Rasa Fumagalli. I'm an attorney and the Director of Medicare Secondary Payer Compliance and Synergy Settlement Services. Prior to joining Synergy, I spent over 20 years as a Chicago-based insurance defense workers' compensation attorney. In 2009, I began specializing in the area of Medicare Secondary Payer Compliance, and I've devoted my practice since then to helping parties address Medicare's potential interest in their personal injury, no fault, or workers' compensation settlements. So let's begin. Medicare is the federal health insurance program for people who are 65 or older, certain younger people with disabilities, and people with end-stage renal disease, permanent kidney failure, which requires dialysis or a transplant, also known as ESRD. As you can see on the slide, this is what a Medicare card looks like. It's always a good idea when you are signing on a new client to ask them if they have a Medicare card. So now, just a little additional background on Medicare. It was enacted in 1965, and at the time it was enacted, the average life expectancy was much shorter than it is now. In 1965, the average life expectancy for a man was around 67, while a female's average life expectancy was in the area of 74. Currently, we have an average life expectancy for a male to be in the area of 75 years, while a female's life expectancy is around 80. Whenever you're representing an individual, it's always a good idea to ask them the type of Medicare plan they may be enrolled in. There are basically 4 different parts of Medicare coverage. There's traditional Medicare, which is Medicare Part A and Medicare Part B. The Medicare Part A benefit is a hospital insurance benefit. As mentioned, it covers inpatient hospital stays, care in a skilled nursing facility, hospice care, and some home health care. Part B insurance covers certain doctor services, outpatient care, medical supplies, and preventive services. Traditional Medicare, or the Medicare Part A and Part B coverage, it's basically a fee-for-service type of payment where the provider agrees to accept a certain fee schedule from Medicare. Medicare pays it once the service is provided. The other 2 types of coverage which you might have under Medicare may be Medicare Part C and Medicare Part D. Medicare Part C plans include everything that's covered by Medicare Part A and Part B, plus more. Medicare Part D plans could be standalone prescription drug plans, or the drug plan benefit might be included in that Medicare Part C plan. Both Medicare Parts C and D are administered by private insurance companies. Rather than being a fee-for-service payment, these plans are paid a fixed amount each month by Medicare, depending upon the health of their enrollees. Medicare Part C and Medicare Part D, like traditional Medicare Part A and Part B, use the Medicare Secondary Payer Act as their recovery vehicle. So what is the Medicare Secondary Payer Act? Well, it is something that was created in the early 1980s to avoid a cost shift of injury-related expenses to Medicare in certain circumstances. And the Medicare Secondary Payer Act can be found at 42 U.S.C. Section 1395 YB2A2. It basically says that Medicare is a secondary payer when payment has been made or can reasonably be expected to be made under a workman's compensation law or a plan of the United States or a state, or under an automobile or liability insurance policy or plan, including a self-insured plan, or under no-fault insurance. When we're talking about payment has been made, that is a settlement. So the Medicare Secondary Payer Act applies to settlements because Medicare views the settlement as a payment that has been made or is being made. So Medicare Secondary Payer Act is intended to prevent the premature exhaustion of the Medicare Trust Fund. And according to the June 2022 Medicare Trustee Report, the Medicare Hospital Insurance Trust Fund is expected to run out of funding in 2028. When this happens, the program is not going to have enough revenue to cover all of the operating costs. As of 2029, there's going to be a 10% estimated shortfall. Now, Medicare Part B and Part D, though, are funded by the government's general revenues and mainly by patients' premiums. Another relevant section of the Medicare Secondary Payer Scheme is 42 CFR Section 411.20A2. And this section basically states that Medicare is precluded from making payment for services to the extent that payment has been made or can reasonably be expected to be made under any of the following: workers' compensation, liability insurance, no-fault insurance. The exception to this, however, is when payment is not reasonably expected to be made promptly. Medicare defines that as within 120 days of receipt of the claim by the primary payer. Medicare does not want beneficiaries to go without medical treatment. So if Medicare makes payment in this situation, the payment is considered to be a conditional payment, which must be reimbursed to the Medicare Trust Fund. Many settlements happen on a disputed basis. And there is a question as to whether a primary payer actually has an obligation to make payment. 42 CFR Section 411.22 states that a primary payer's reimbursement obligation to Medicare may be demonstrated by a judgment, a payment conditioned upon the recipient's compromise, waiver, or release, whether or not there is a determination or admission of liability, a payment for items included in a claim against the primary payer, or by other means. This particular provision indicates that, whenever the settlement terms are releasing specific claims for future medical treatment for specific injuries, this is going to be viewed by Medicare as the primary payer's reimbursement obligation. When this provision also talks about other means, they're generally talking about contractual situations for no-fault policies and so forth. The enforcement mechanism for this conditional payment reimbursement obligation is that if there's a failure to reimburse the Medicare Trust Fund, Medicare can file suit directly for double damages against any or all entities that we're responsible for reimbursing these conditional payments. And Medicare views that as a very broad group of entities. So we're talking about the primary payer, the insurer, we're talking about the attorneys, we're talking about the providers. So this is a very somewhat broad threat of a double damage suit. It's also important to note that these Medicare Advantage plans, these Medicare Part C, Part D plans, they also have the same rights of recovery as Medicare under the Medicare Secondary Payer Act, so you do not want to ignore their reimbursement rights. When we're trying to make sense of the Medicare Secondary Payer obligations in a settlement, it's helpful to think of three different obligations or three distinct parts. And the three parts are like pieces of a puzzle that all fit together to make up that Medicare Secondary Payer Compliance framework. There is the obligation to address past medical payments or conditional payments. There is an obligation to report settlements to Medicare, whether it is by the beneficiary or under Mandatory Insurer Reporting under Section 111. And there's also an obligation when it comes to post-settlement injury-related care. You should avoid cost shifting these expenses to Medicare when the settlement is funding or has a component of future medical that is being released in the settlement. The first part of Medicare compliance begins with conditional payments or payments that were made by Medicare that are injury related and occur before settlement. Before 2013, people could get numerous letters from Medicare's Benefits Coordination and Recovery Center seeking to collect really low dollar conditional payments, like $10. But this $10 conditional payment demand was being pursued very vigorously with many, many conditional payment letters. Basically the effort that Medicare was putting into collecting was not matching up with what Medicare was actually recovering at times. Now, the Strengthening Medicare and Repaying Taxpayers Act of 2012, or the SMART Act, was signed into law in 2013, and it sought to remedy this. It primarily determines annual settlement threshold figures. If a settlement falls below the annual threshold, the settling parties are exempt from Medicare Secondary Payer Compliance obligations. As of January 1st of this year, 2023, CMS's threshold for physical trauma-based liability insurance settlements is $750. This means that if there are conditional payments by Medicare, they do not need to be repaid. There's also no need to report this settlement, either under mandatory insurer reporting or just the regular, beneficiary self-report obligation. These CMS review thresholds for no-fault insurance and workers' compensation settlements are also $750 unless the carriers have an ongoing responsibility for medical or ORM. Second part of the Medicare Secondary Payer Compliance puzzle involves settlement reporting. And now there are two different types of reporting that take place. There is the beneficiary's obligation to self-report whenever they have an accident that is caused by someone else's fault, like a car accident or a workers' comp type of injury. There's an obligation on their part to also report the settlement and provide settlement documents and seek to get information regarding conditional payments. The other reporting that has to take place is done by the defense, and it's Section 111 Mandatory Insurer Reporting. Now, this obligation was something that was rolled out in 2010, and it is essentially the enforcement mechanism for the Medicare Secondary Payer Act. It is intended to help Medicare avoid making improper payments or payments when there is a primary payer that is available. It is also intended to help Medicare recover payments that were made. The reporting is done by a responsible reporting entity, or RRE. It is done by liability, including self-insurance, workers' compensation, and no-fault carriers. So the RREs have to query the Medicare system on a regular basis to figure out when claimants are eligible for Medicare while their claims are open. When a workers' compensation case, MedPay, or personal injury protection plan accept a case, they have an obligation to report ongoing responsibility for medical, or ORM. And it's also important to note that this mandatory insurer reporting is only happening when a person is on Medicare. Another thing that needs to be reported is the total payment obligation to claimant, or TPOC report. So the TPOC report is different than the ORM report. When you have ORM reporting, you may also have a TPOC report later on. And this total payment obligation to claimant report is done whenever there's a settlement with a Medicare beneficiary involving a physical trauma that exceeds $750. And that, you might recall, is that same threshold for conditional payment claims. Now, the TPOC date is the date that the payment obligation was established, the date that the written agreement is signed, unless court approval is required. If no written agreement, the date of the payment. It's not the date where you and counsel are at a mediation and you come up with a tentative agreement. So what is actually being reported? First off, you're going to have certain data points, such as the injury victim's first name, last name, date of birth, gender, Medicare beneficiary identifier, or the Social Security number, and you can just give the last 5 digits. The TPOC report is also going to include the date of the accident, settlement amount, and the ICD diagnosis codes for the alleged illnesses, injuries that are claimed and or released in that settlement, judgment, award, or other payments. Diagnosis codes are extremely important when it comes to conditional payment recovery and the avoidance of post-settlement injury-related issues. Medicare encourages RREs to supply as many valid diagnosis codes as possible, because this is going to lead them to have more accurate coordination of benefits when it comes to looking at payments that were made and recoveries. Medicare, though, in a recent webinar on December 6th of 2022, said that in order to accurately identify claims for recovery purposes and to prevent Medicare from paying primary in the case of ORM, it's important to submit diagnosis codes that pertain to the injury and not codes for pre-existing or unrelated conditions. The more accurate the reporting of the diagnosis codes, the more accurate the recovery process will be. When a person is looking at an individual's medical records, you are likely going to see a ton of ICD-10 or ICD-9 diagnosis codes. And a lot of those codes pertain to pre-existing conditions or conditions that have absolutely nothing to do with the injuries that are being sustained. So it's important to look at the diagnosis codes that are listed and actually look them up to see which conditions are being reported and coordinate the reporting with the defense to make sure that they're not reporting pre-existing diagnosis codes. Mandatory insurer reporting obligations fall on the defense, the carriers, and the RREs. And this reporting obligation is something that could result in civil monetary penalties when the RREs are violating the mandatory insurer reporting rules. The SMART Act that I mentioned before talked about the possibility of violations being fined and up to $1,000 per day for each claim. They did not, however, provide any guidelines in terms of, well, what circumstances might mitigate this penalty. And to date, it's my understanding that the penalty has never actually been applied. There are, however, final rules regarding civil monetary penalties for Section 111 reporting violations that have been in the works since February of 2020. The final rule is expected to come sometime in the spring, possibly this month, and they contemplate civil monetary penalties of up to $1,000 for each day when the RRE failed to report within 1 year of the coverage effective date of settlement, or establishment of payment obligations, or when the RRE provides Section 111 information that conflicts with information provided in response to Medicare Secondary Payer conditional payment recovery efforts. There are also a few other circumstances that were listed in the proposed rule, so we will keep you posted when these final rules actually come out. At one point, Medicare was using the ICD-9 codes rather than ICD-10 codes. The ICD-10 codes now are the codes that must be used. They are much more robust than the ICD-9 codes. They contain, I believe, 5 times more diagnosis codes that are more specific. And the more specific the code, the more targeted the Medicare recovery efforts. They are maintained by the World Health Organization. They're used for collecting data, developing claim reimbursement systems, and conducting disease-related studies. And CMS, though, does exclude certain ICD-10 diagnosis codes from Section 111 reporting. The valid list of codes is available on the CMS website. So at this time, I will turn the presentation over to my colleague, Teresa Kenyon, who will go over the conditional payment recovery process in greater detail.
Thank you, Rasa. As Rasa indicated, we are going to now turn to the Medicare conditional payment process, specifically looking at the different steps to the Medicare portal. I am Teresa Kenyon. I am the Director of the Lien Resolution Department here at Synergy Settlement Services. I am a licensed attorney in both California and Kentucky. And prior to joining Synergy, I worked at the Rawlings Company for almost 8 years. And while there, I was fighting on behalf of those health insurance companies. Now I'm on the other side fighting against them, and I've got a team of subject matter experts on all the different lien types, but specifically a team of experts on Medicare, which we're going to talk about here during this webinar. We've got over 300 years of combined experience, and the team passionately fights to save money for the injured parties.
We are going to go through the Medicare lien process. A lot of this is borrowed from the Medicare website. The Medicare website is actually pretty decent when it comes to providing some basic step-by-step instruction. So the first thing when you, as the attorney, know that you are pursuing some kind of claim on behalf of a client and that your client is a Medicare beneficiary is to report the case to the BCRC. And it's stated that the BCRC must be contacted if any claim is made against any alleged tortfeasor that has liability insurance, if there is no fault insurance involved, or a workers' compensation claim. So when you contact the BCRC to report the case, you want to make sure you have this kind of information. So just the actual beneficiary's information, you should probably have that in your file. So your client's name, their Medicare number, their gender and date of birth, as well as their address and phone number, and then some information about the case. So we want to be reporting the type of claim, the insurer's name and address, a description of the injury, and then the date that we're talking about for the injury or accident. So Medicare has a portal. This is a screenshot of the Medicare portal case reporting page. You can see that this is where you put all that information that we just covered. And this is actually, if this isn't something that you've ever seen before, worth checking out. It does make things easier, but this is definitely what Synergy uses as often as we can to handle these as efficiently as possible. So the second step is that the BCRC issues a rights and responsibilities letter. I've just got a screenshot here of what that letter looks like. So after the occurrence is posted, then BCRC sends this out. This letter explains what information is needed from the beneficiary and what information can be expected from the BCRC. Next step is that BCRC goes ahead and takes a look at the claims, and they identify Medicare's interim recovery amount, and they issue the conditional payment letter, the CPL. So they take a look at all the claims, and then based on the details that have been provided about the type of incident, the injuries that are alleged, they go ahead and put together a lien. Medicare runs from the date of incident through the date of settlement. So a lot of times when you have them when you request a conditional payment letter for the first time around, the case isn't settled yet, so it's not final. But within 65 days of the issuance of the rights and responsibilities letter, they will send the CPL letter and the payment summary, which lists all the items and services that they've paid that they're identifying as related to the case. This is just a screenshot of what it looks like. In this particular case, it says that as of the date of this letter, based on available information, they've identified $2,700 in conditional payments that they believe to be associated with the case. And they're also saying that they enclosed a listing of the payments, that it's not final, and that you should obtain a final amount before settling the case. This is just a screenshot of what the payment summary form looks like, just in case you haven't seen it. So they've got the diagnosis codes. You can tell there that they list multiple codes on one line, and you can see what the billed amount is and then what the actual conditional payment is as well. I mentioned the Medicare portal a little bit ago. So it's the Medicare Secondary Payer Recovery portal, the MSPRP. And I just wanted to highlight the kind of things that you can do in the portal if you're not already using it. Synergy definitely uses it for efficiency's sake. So you can submit beneficiary proof of representation, beneficiary consent to release, or insurer letter of authority documentation. You can also request the conditional payment information, so you can get that conditional payment amount. You can get the updates that way as well. You can request a printed or electronic copy of that letter, and you can also request a final conditional payment amount for a case that's approaching settlement. That's a whole other process that we do sometimes utilize. You can dispute the claims that are in that conditional payment. So if there are any claims that are unrelated, or if there's some kind of argument you can make as to why they shouldn't have to be paid back, you can do it through the portal. You can also initiate the final demand. If you agree with that CPL amount, then you can click the button and turn it into a final demand. You can view the status of any kind of communication that has been sent from Medicare. You can also submit the case settlement information. So when the case is settled and you want to go in and get the final demand, you can give them all that information, upload the settlement documentation to get that process going. And then finally, you can submit the waiver compromise redetermination request, the request for refunds right there in the portal. And you can also see the details of it, when they've received it, when they made a decision, and what the decision is. So that is certainly helpful. Sometimes Medicare does not issue a CPL, the conditional payment letter that we mentioned before, but instead they issue a CPN, a conditional payment notification. And this is done when Medicare finds out about the pending claim once it's already settled. And that is often the case if it's the defense that has reported it for the first time. So Medicare will send out the CPN. If you, as plaintiff counsel or the beneficiary themselves, send a response within 30 days, then the correspondence will be reviewed and a demand letter will be issued. That demand letter will include the procurement cost reduction. If a CPN is issued and they don't receive any kind of response from you as the attorney or the beneficiary, then no procurement costs are taken into consideration, and the demand letter that comes out is for the full amount. So it's always best to report the settlement, report the case to begin with, report the settlement information yourself so that you can make sure that those procurement costs are being considered. So there is a dispute process with Medicare if it's believed that any of the claims that are included on a CPL or a CPN should be removed from Medicare's conditional payment amount. Then you've got to provide documentation supporting that position and present it to the BCRC. The process can be handled by mail, fax, or through the portal. And if the BCRC agrees, then they will adjust the conditional payment amount to account for any claims that are not related to the case. Sounds simple enough, but there are plenty of times where you submit a dispute and they do not remove the claims. So oftentimes it is a multiple attempt to get the claims that should not be there removed, and we definitely have a lot of experience with that. So settlement has occurred. You are in receipt of funds, and the BCRC needs to be notified. So the details that they need are the date of settlement, and that's very important because that's when they will cut off the inclusion of treatment in their lien amount. The amount of settlement, that includes all settlements. They do have different files for a BI versus a UIM. If it all settles around the same time, it can be submitted as one. We do that sometimes. They also need to know the amount of any attorney's fees and costs because that is important to the reduction that needs to take place for procurement costs. And they have created a document that is called the Final Settlement Detail Sheet that makes it easy to submit that information to them. Got a screenshot here of it. It's just that bit of information, but it's just a clean way to submit the information to Medicare. After settlement information is entered, then the next step is for a final demand to be issued. So the BCRC will do a final look at the claims that have been paid by Medicare. They will apply a termination date to make sure that they're not including claims that are after the date of settlement, but they can add new claims. So these could be new claims that are prior to the date of settlement that never made it onto a prior CPL. And really, you could have received a number of CPLs over the course of your handling of the case. And then all of a sudden, the final demand has new claims. Maybe it's $20,000, $30,000 more than what the prior CPLs are. That does happen, and that's why they say that a final demand is not, or Medicare's lien is not final until a final demand is issued, because these claims that get added, they do remain if they are valid and if they are prior to the date of settlement. So the final demand will include all those claims, and then it will subtract the procurement cost. And then once that final demand is issued, Medicare must be paid its final demand amount. If not, then there is interest that is assessed. So we do recommend paying the final demand within 60 days, or else the interest will begin to accrue. And ultimately, if it's still not paid, then it gets referred to the U.S. Treasury for an enforcement action to recover the unpaid amount. We'll get to that in a minute. So interest does accrue if the debt is not repaid or not otherwise resolved within the time period specified in the final demand letter. And that interest is assessed for each 30-day period that the debt remains unresolved. Even if an appeal or a waiver is requested, the interest will continue to accrue. So it's strongly suggested that you pay the demand amount, no matter what, to avoid the accrual of interest. If the payment of that demand is otherwise unjust or unfair, then that's when the waiver or appeal is appropriate. And if it's granted, then a refund is issued. And finally, if the debt remains unpaid, then the next step is for a referral to the Department of Treasury. So you definitely don't want to get to this point, but the notice of delinquency is through an intent to refer letter, which is a notice of the BCRC's intent to refer the debt to the Department of Treasury offset program for further collection activities. The intent to refer is sent 90 days after the final demand letter if the full payment has not been received at that point. And if the full repayment is not received within 60 days of the intent to refer letter, which is 150 days from the final demand letter, then the debt is referred to the Treasury once the BCRC handles any outstanding correspondence that they may have. So CMS may also refer debts to the Department of Justice for legal action if it determines that the required payment has not been paid. And the law also authorizes the federal government to collect double damages. We've heard about that before, but the collection of double damages from any party that's responsible for resolving the matter but refuses to do so.
And that concludes today's webinar. Rasa and I both thank you for your attention and hope that you learned something along the way. Here is our website address and our phone number if you have a case that you would like for us to handle for you. Both Rasa's team and my team are standing by. Thank you.